Afternoon, sir. Can you see and hear us?
Yes, thanks.
Thank you. Good afternoon, Mr. Wilson. We were looking at the receipts and payments mismatch bug.
Yes.
And the record, either the record of the meeting or a record for the meeting in October 2010, which was sent to you by Mr. Simpson.
Yes.
Even if you thought that the receipts and payments mismatch issue could not have affected Mrs. Misra's case, because her case was one which relied on data under the legacy Horizon system. Did it occur to you that it should be disclosed in any case involving Horizon Online?
Horizon Online being the new?
Yes.
Yes.
What steps did you take to ensure that it was so disclosed?
I can't recall.
We've seen no record of a meeting or email in which any advice or instruction was given that it should be disclosed in future cases or existing cases that relied on Horizon Online data.
Yes.
Did you discuss the issue with Jarnell Singh or Julia McFarland?
I certainly discussed the immediate issue that we had.
What was the immediate issue you had?
The immediate issue was notifying each of the branches individually what had happened.
Wasn't even more immediate than that any case in which there was a prosecution founded upon data that included the relevant period?
Yes.
Did Mr. Singh take a particular interest in this issue because of the Seema Misra case?
I honestly don't know whether Mr. Singh did or Ms. McFarland at the time. I can't think back other than I recall that from the documents that I responded pretty quickly and copied them into the email, and I'm pretty sure I will have had a discussion with them probably prior to even speaking to Alan Simpson, but I can't recall any further details.
Can we look, please, at poll 302 8838 again, please? And go to page 6, please. This was the second of the attachments to Mr. Simpson's email to you.
Yes, Gareth Jenkins.
It's a 4-page report by Mr. Jenkins, dated the 29th of September. And if you look at the foot of the page, can you see that it seems to have been saved in or taken from a C drive attributed to Jarnell Singh?
Yes.
And can you see that it was printed at 4:38 on the 8th of October?
Yes.
The 8th of October was a Friday, and Seema Misra's trial started on Monday, the 11th. Okay?
Yes.
What discussion was there about whether Mr. Singh needed to disclose either this document or some other document recording information about the receipts and payments mismatch bug?
I don't recall.
You said in your witness statement, we saw it in paragraph 17, that you now accept that the wrong decision was made.
Yes.
Not to disclose it.
Yes.
Or to not disclose it. Who made that decision not to disclose the information about the receipts and payments mismatch bug?
No, it was I'm saying I made the wrong decision.
Yes. And so were you the relevant decision maker then?
You mean in relation to the Minister file?
Yes.
No, I wasn't. I was saying in general terms, my view was there were two different systems. I'm not saying that I communicated that with anybody else or that I persuaded anybody else to be of that view at all. I can't recall the discussions, but looking back, that's how I viewed it.
Isn't it likely that you had a discussion with Mr. Singh? You referred in an email that we saw before lunch to meeting with him and Julia McFarlane on the Friday.
Yes.
Mr. Singh has printed out Gareth Jenkins' report.
Yes.
It's
He
22 minutes to 5 on a Friday
Yeah.
when this is printed, and he's got a trial starting on Monday.
I mean, he may well have printed this out to take it to court with himself. I don't recall.
If he did, it stayed in his bag because it was not disclosed. My question is, did you discuss it with him and Julia McFarlane, the disclosure of it into the Seema Misra trial?
If I'd said to him, for the sake of argument, it's not disclosable, I don't see why he's printing it out on the Friday afternoon at all. I think that's probably an indication that he was taking it to court.
The notes we saw showed that Mr. Jenkins was present at the meeting.
Yes.
This note is written by Mr. Jenkins, and if we go forward to page 9, please. And look at the last paragraph. Sorry, can we look at the next page if there is one? It must be page 8. And scroll down, please. Yes, communication with the post office. Mr. Jenkins says, once we have the information from section 4, which will enable us to identify the full scope of the issue, we need to communicate this to the post office through the problem management mechanisms. We'll then need to get Post Office Limited to agree if and how we should be correcting the data. Post Office should be able to check up on PulseApp to confirm that these discrepancies are still visible even though they've been lost in branch. As discrepancies are normally losses, then a loss discrepancy would normally work in the branch's favour. So there's no incentive for the branch to report the problem. Also, if we do amend the data to reintroduce the discrepancy, this will need to be carefully communicated to the branches to avoid questions about system integrity. Was there a concern within the post office that any communication to the branches about the problem should avoid questions about system integrity?
Well, I think inevitably, if you're going to tell them that this is the problem, people will question it. I don't think they can get around that, whether they like us informing the branches or not. Post Office Limited are stuck with the problem.
Mr. Jenkins was going to be called as a witness in the trial that was going to start the following Monday.
Yes.
Did you, or to your knowledge, Mr. Singh, speak to Mr. Jenkins after your meeting to communicate what the Post Office's position was concerning disclosure of this issue in the Misra trial?
I didn't. I don't know whether Mr. Singh did.
Was anything agreed in your meeting with Mr. Singh about what would be communicated to Mr. Jenkins?
I'm not sure I had a meeting with Mr. Singh specifically about Misra. I think I had a discussion with him and Juliet about the problem.
But you're there on a Friday afternoon with Mr. Singh knowing he's got a trial starting on the Monday. Surely the immediate issue, the really immediate issue is, have we got to disclose it?
Well, I go back to what I said earlier, that I think if he's copying that ad at 6:38,
4:38.
sorry, 4:38, he must be intending to take it to court with him. I mean, I can't see why he would print it out otherwise.
Are you implying that you may have had the belief that Mr. Singh did intend to disclose this in the Misra
No,
case?
I have no idea. I would like to be able to answer your question, but I have no idea what was in his brain.
If instructions hadn't been given to Mr. Singh, or Mr. Singh hadn't made a decision to communicate with Gareth Jenkins, there would be a risk that in the course of the evidence that Gareth Jenkins was to give, he might disclose this.
Yes.
Was there any plan to tell Mr. Jenkins what he could or could not say when he gave evidence in the Misra case?
No. And certainly not from myself, no. I mean, personally, I think that Mr. Jenkins, dealing with this issue immediately before Misra, I would have thought he would have told Mr. Tapford in any event.
Why do you think Mr. Tapford would be involved?
Well, because he was the person who was going to was going to examine him in chief.
We've seen from a number of communications that when any issue concerning disclosure arose, Mr. Singh contacted Warwick Tapford for his advice.
Yes.
We've seen that when Mr. Singh wanted something drafted, he asked Mr. Tapford, and Mr. Tapford would sometimes draft letters, and in one case even an email for Mr. Singh.
Yes.
Do you know why, in relation to this issue, there was no communication to Mr. Tapford about the existence of the receipts and payment mismatch bug?
No, I don't. It may be that he thought it's late on a Friday night, I won't be able to get hold of him.
You now say that you accept that the receipts and payments mismatch bug should have been disclosed, I think, to the defence in the Misra case.
To everybody. Or anybody in the future, yes.
Is that acceptance or concession made because you know that leading counsel for the Post Office in the course of the Hamilton trial, the Hamilton appeal rather, himself accepted before the court that the receipts and payments mismatch bug fell to be disclosed in all prosecutions?
I wasn't aware of that detail anyway. This is something that was in my brain.
You knew at the time the test for disclosure under the CPIA.
Yes.
The notes that you've been sent made it clear that the bug impacted on balances.
Yes.
And the notes, as we saw before lunch, made it clear that there was a potential impact on ongoing legal cases.
Yes.
Given those three things, how is it that you decided that it need not or should not be disclosed?
I viewed it as being a completely different system, and therefore no chance of the two colliding.
What's changed now?
Well, I've thought about it more. Obviously, I've seen lots more papers. I've listened to the YouTube, some witnesses, And I just think that we should have basically disclosed any bug at any time.
Can we turn, thank you, that can come down, to the duplicated records
Yes.
issue. That's the third of the references that you gave in that paragraph 17
Yes.
of your witness statement. And in paragraph 17, you say that that too was not disclosable because it related to Horizon Online and therefore didn't affect Horizon legacy cases. Can we look, please, at FUJ 0012 2995? And can we start with page 5, please? And if we just scroll down. Thank you. Yeah, so 13th of September, Mark Dinsdale to Juliet McFarland, duplication of transaction records in ARQ returns. Juliet, do you think this draft would be okay? I'll run it past Penny at Fujitsu and ask them to top and tail it into a witness statement if you're happy with it. And then the draft. On audits of transactions, there occurs a duplication of records when records were in the process of being recorded purely for audit purposes from the correspondence servers to the audit servers. This has always been the case. However, the mechanism used on Horizon to retrieve audit data took this into account and only presented one instance of such duplicate data. As offices have migrated to the new Horizon Online application, any request made for audit data during this period, the mechanism used to filter out duplicates did not remove them from the audit data. The duplicates only occur in the audit data, does not affect the actual physical transactions recorded on any counter at any outlet. This problem has now been resolved. However, a small number of audit requests made during the period from legacy Horizon migration until the resolve will show the duplicate transactions. What do you understand is being said by that email?
I think it is saying that under the old system, there wouldn't be a duplication, but under the new system, there is.
And it's afflicting data that is or may be presented to a court.
Yes.
Thank you. Can we move on to poll 0016 9416 and scroll down to the bottom of the chain at pages 3 at the bottom and on to page 4. This is perhaps an easier to understand explanation. You'll see it's from Penny Thomas to 3 people, Sue Lowther, Mark Dinsdale and Jane Owen in the post office. We've identified that a number of recent ARQ returns contain duplicated transaction records. With Horizon counters, the mechanism by which data is audited has always worked on the principle that it's acceptable to audit the same data more than once, in particular if in doubt as to whether or not it has been previously audited successfully. The mechanism used on Horizon to retrieve the data took this into account and only presented one instance of such duplicate data in the ARQ extracts. It's recently been noticed that the Horizon Online retrieval mechanism does not remove such duplicates. A quick scan of the ARQs provided to the post office since the change to the new system indicates that about 35% of the ARQs might contain some duplicate data. A peak's been raised to enhance the extraction toolkit. However, until the fix is developed, tested and deployed, there's a possibility that data is duplicated. Skip the next paragraph. We've identified a scenario with postal services transactions where multiple identical mails are accepted, but postage labels are printed. I don't think I need to read the rest of it. And if we carry on scrolling up, please. Thank you, and again. And just a little bit more, and once again, thank you. we can see that Jane Owen sends out to a number of people within the post office that email we've just read and says, Mark, Alan Simpson and myself have had a conference call today to look at potential problems this is likely to cause. Firstly, the suggested workaround will need to be put to our legal team, and until that has been agreed, any further ARQ requests, including those that have already submitted, will be suspended. There are two cases currently with the court. West Byfleet, that's Seema Misra's case, yes?
Yes.
And Porter's Avenue. I will speak to Lisa and John about these, as we need to know what in the way of ARQs and the corresponding statements have been presented to court. And then there's a list of additional cases. And if you scroll down, a lot to digest. Ask for clarification if you need it. And then if we carry on scrolling up, we'll see that's sent on to John Longman, who is the investigator in the Seema Misra case.
Yes.
Can we go, please, to poll 306-1056? This is a notice of additional evidence in the Seema Misra case. If we scroll down a page, please. We'll see that it's signed off by Mr. Singh. And then the next page, we'll see it's a witness statement from Mr. Jenkins. Can you see that?
Yes.
Of the 8th of July. And then if we go to page 3, can we see with Horizon counters the mechanism by which data is audited, etc. And then the next paragraph, in January 2010, a new Horizon online application was introduced, etc., etc. We see him giving disclosure of the
Duplicates.
the duplicate issue, don't we?
Yes.
You said in your witness statement that it was your view that it didn't need to be disclosed because it afflicted Horizon Online only and not Legacy Horizon.
Yes.
Why did you take that view?
Well, because, like I said before, I saw them as two different systems.
In fact, we can see that disclosure of this bug, I'll call it,
Yes.
was given,
Yes.
even though, in your view, it afflicted only Horizon Online.
Well, I obviously didn't communicate it with Janelle or Juliet, because I think Juliet, this was Juliet's duplicate problem.
Why was it Juliet's duplicate problem?
Because she was the one on the email who was contacted by, was it Mark Dinsdale?
Mark Dinsdale.
Yeah. And I think she organised the statement. And whether this is the same statement or not, I'm not sure, but it certainly was disclosed on the Misra case, yes.
So just help us one more time then. Why did you think it needn't be disclosed and yet it ended up being disclosed? Because you've drawn a distinction between things that affect Legacy Horizon only and things that affect Horizon Online only.
Yes.
As the basis for our explanation
I
for why the Misra
When I was
case.
making my statement, I just recalled believing that there were two different systems, and therefore disclosure was not necessary. Now, that was my memory at making the witness statement. And clearly it has been disclosed in this particular case, and clearly I didn't give anybody an instruction to that effect.
Thank you. Thank you. That can come down. Can we turn directly to the Seema Misra case then and start with the charging decision? In paragraph 5 of your witness statement, there's no need to turn it up, you tell us that you do not know who authorised the prosecution of Mrs. Misra.
Yeah, it's probably in the paper somewhere. I just couldn't find it.
Well, I don't think we can tell who authorised it either.
Right.
How would you, what piece of paper would you expect to exist to show who authorised the prosecution of Seema Misra?
Well, I'd expect to see a letter on the file from the casework team informing us who the decision maker was and that they'd made the decision.
So you would expect an investigator's report coming in with some associated paperwork.
Yes,
You'd expect some advice going out from a member of the criminal law team with advice on charge.
yes,
And then you would expect a letter from the casework team saying Mr. X or Mrs. X has decided to authorise prosecution.
yes.
In a case like Seema Misra, would you have seen papers in and out like that?
Yes.
And so to what extent would you familiarise yourself with the issues, or would you simply say this is a letter concerning Seema Misra, that's got to go to Jarnell?
Yes, I received the post every day, unless I wasn't in which case I delegated it to whichever lawyer, senior lawyer was in. And so I will have seen the post, divided it up, and I will have taken it around to the lawyers. Whether they were in or not, I'd put it in their in tray, because they may be in later in the afternoon. So I would see post coming into the office, yes.
To what extent did you engage with the contents rather than just seeing to whom it was addressed and therefore whose in tray it should go to?
Oh no, I think if there was something in the contents which was interesting or worrying, or for whatever reason I wanted to discuss it, I would have taken it to the lawyer and discussed it with them.
So at the time you were presumably aware that Mrs. Misra had been charged with both theft and false accounting and had pleaded guilty to the false accounting charge, albeit the Post Office didn't accept that plea and was seeking a conviction for theft.
Yes.
When you gave evidence back on the 12th of October, you told us that you had directed the lawyers in the criminal law team not to charge both theft and false accounting.
Yes.
Did you discuss with Mr. Singh why Mrs. Misra had been charged with both theft and false accounting?
I don't know whether I did on the Misra case, but I certainly remember having discussions with both Janelle and Juliet in relation to putting both sets of charges together because of the case of RV Eden. And it was a bone of contention that I did have with them.
And what was the nature of your bone of contention?
Well, that they should be following what RV Eden said.
And what was your understanding of what Eden said?
Basically, you have to pin your colours to the mast.
We've heard some expert evidence who said that the Court of Appeal in Eden made it clear that there will be cases where it is appropriate to have a charge of false accounting as an alternative charge to theft. Did you know that at the time?
Yes, I read Eden. It was a post office case. It was one of the first cases that was drawn to my attention by my predecessor.
What did you understand as to the circumstances in which it was appropriate to charge theft as false accounting as an alternative to theft?
I can't remember now, but I imagine where there were two separate incidents which would justify you separating the two charges.
Is it fair to say that some lawyers within the criminal law team took a different view to you on the propriety and desirability of charging both?
No, that's a fair comment.
And what reasons, if any, did they give for taking a different view to you?
I can't remember. I mean, they may have attempted to argue what we've just been discussing about charging them both. I don't know.
Did anyone give you an explanation along the lines of, if we put false accounting on as count 2, 3, 4, 5, 6, or whatever, we often get pleas to those?
I don't think they would be that. I don't think they would say that. They might think it, but I don't think they would say it to me.
Can I turn to some other disclosure issues in MISRA? You've told us already candidly today that you accept that the wrong decision was taken on disclosure in relation to issues that you believe related only to Horizon Online and did not afflict Legacy Horizon. But you don't mention in your witness statement documents that could or did relate to the Horizon system before the switch in 2010. I just want to explore some of those with you, if I may. Can we start, please, with poll 304 4557? If we go to the last page of this document, please, you'll see it's, we just scroll down, an advice from Warwick Tatford dated the 5th of January 2010. You remember when we were looking at that long disclosure request that was cut into an email?
Yes.
Eventually, Mr. Singh sent that on to Mr. Tatford asking for his advice. Do you remember we saw that this morning?
Yes, yes.
And this was the reply. If we go to page 3, please, and look at paragraph 7, Mr. Tatford advises, I also think that our disclosure duty requires us to ask Fujitsu whether they are aware of any other Horizon error that has been found at any sub-post office. I anticipate that there will be none, but it's important that the check is made. Did you see this advice?
I don't recall seeing it, no.
Would it be normal that as part of the process for post coming in, post going out, that you see advices like this?
If it came in via the post, yes.
Was there any system in place for you to see significant documents that came in by email only?
I had access to each of the lawyers' email addresses for when they were on holiday, but I can't say other than when they were on holiday, I accessed their emails.
You weren't checking whilst they were still there?
No.
Did that piece of advice that we see there ever make its way through to you, so far as you can recall?
I can't recall it. I'm sorry.
Can you recall whether it made its way through to you in the context of any other case that prosecution counsel was advising that Fujitsu should be asked of any other Horizon error that has been found at any sub-post office? That's quite a broad statement, I think, isn't it?
Yes. I don't recall.
Presumably, if you drew a distinction between Horizon Online and Legacy Horizon, such advice might conflict with that distinction.
Yes, but again, I'm not sure I communicated it with either Mr. Singh or Ms. McFarland, and I certainly wouldn't have communicated it with counsel.
In any event, if you remember the formulation there of Mr. Tatford, we need to ask Fujitsu. Our disclosure duty requires us to ask Fujitsu any other Horizon error that's been found at any other at any sub-post office. Can we go forward to please to FUJ 0015 2902? And look at page 2, please. Can we see an email here from Mr. Longman dated the 1st of February, so just under a month after that advice? And can you see paragraph 3 of Mr. Longman's email to Fujitsu?
Yes.
He says, when Gareth completes his statement, could he also mention whether there are any known problems with the Horizon system that Fujitsu are aware of? If there are none, could this be clarified in the statement?
Yes.
Would you agree that what Mr. Tatford has advised has been watered down? Maybe I can help you. The first respect in which
Fujitsu.
exactly. The first one was asking for a third-party provider of the computer system, so a third-party disclosure source, whether it, the corporation, was aware of any other Horizon problem at any sub-post office.
Yeah.
That's been translated to an address to an individual to mention something.
Yeah, I mean, I'm not seeking to argue with you, but the second sentence also goes on to say, are any known problems with the Horizon system that Fujitsu are aware of? So he's sort of semi-redressing it.
He's narrowing and then broadening it.
Yes.
Did this translation or transliteration of Mr. Tatford's advice asking the post office to address the corporation into any mention in a witness statement get revealed to you at the time?
No, I don't think so. I understand, though, that Mr. Jenkins did actually put in a witness statement, I'm pretty sure, in the Misra case.
He did, and before he did, there was, and I'm not going to take you through it all,
Yeah.
In the light of your answers. He said that he was unhappy or unwilling to answer directly question 3.
Without the data.
No. He was unhappy or unwilling
really?
to answer directly question 3.
I have to say I'm surprised at that. I thought he'd said that there was none.
This kind of exchange of information,
Yeah.
would you expect it to be disclosed in criminal proceedings?
If he's saying he can't give an answer to that, and he's working in Fujitsu, definitely.
You were responsible in the sense of being accountable for the work of your lawyers in the criminal law team.
Absolutely.
But were you also not responsible because others sought your guidance on how to approach issues of Horizon integrity, as we've seen in the emails of this morning?
Yes. Is this about me endeavouring to help them?
Yes.
Yes.
To what extent was the Post Office's strategy in the prosecution of Mrs. Misra informed, in your understanding, by an objective of deterring other sub-postmasters from raising concerns about Horizon?
That should not have been a concern at all.
I know it should not have been. To what extent was it?
I don't believe it was.
You've read, I think, what the Court of Appeal said about the Seema Misra case in the Hamilton series of appeals.
Yes.
In the light of that, do you agree on reflection, that the Post Office and the criminal law team did not fulfil its duties under either the Code for Crown Prosecutors to evaluate the evidence in support of the relevant charges, nor discharge its disclosure obligations under the CPIA?
I wouldn't seek to argue with the Court of Appeal.
That can come down, thank you. You confirm in your witness statement in relation to obtaining expert evidence that firstly you gave no instructions to Mr. Jenkins in the course of the Seema Misra case.
I can't remember giving any instructions to Mr. Jenkins in any case.
That's paragraph 15.3 of your witness statement.
Yes.
You confirm that you do not know whether Mr. Singh or anyone else in the criminal law team gave Mr. Jenkins such instructions in the Misra case.
I mean, when you say instructions, you mean directions to do something?
Yes.
I can't remember directing any witness to do any particular thing.
And you tell us in your witness statement, it's paragraph 15.4, that you do not know one way or the other whether anyone gave Mr. Jenkins any explanation as to the duties of an expert witness in the Seema Misra case.
No, I mean, I assumed that Mr. Tapford would have taken him through that during the course of the trial.
You say that in paragraph 15.4,
Yes.
where you're addressing the question of whether anyone, whether you or anyone else, explain the duties of an expert to Mr. Jenkins. And you say that you believe Mr. Jenkins would have been questioned in court
Yes.
about his qualifications, experience, and the basis for his opinions.
Yes.
Are you by that suggesting that whether a prosecution witness was being called as an expert and whether their evidence was admissible as expert evidence was a matter to be determined by the court at trial?
No, I don't think I'm saying that. What I'm saying is that him and counsel would have questioned Mr. Jenkins, so it was clear to the court that he understood that his duty was to the court and not to those of us who were instructing him.
That may be so, and that may be a necessary part of adducing expert evidence in court. We're interested in the antecedent stage, i.e. what happened before. Are you suggesting that because when it got to court, counsel may ask questions about qualifications, experience, and basis of opinions, there was no necessity to do any of that beforehand?
No, we clearly got it wrong with how we instructed Mr. Jenkins in terms of his expertise. And I remember you going through a very long list with me on the first day of my evidence, and I believe I accepted that what you were saying was right and that we were wrong. Or I was wrong.
And I was just checking that what you now say in paragraph 15.4 of your second witness statement
Yes.
is not a gloss on that, i.e. because qualifications, experience and basis of opinions are addressed at court,
Yeah.
there's no need to do it beforehand.
No, I'm not saying that at all. I'm accepting what you said to me on the first occasion, that I gave evidence, and I'm not trying to gloss it.
Thank you.
I'm not excusing myself.
Thank you very much, Mr. Wilson. Can we turn to what happened after the trial then, and look at poll 309 3686. And look at page 5, please. foot of the page. Just scroll down a bit longer. Thank you. This is sent by John L. Singh, Secretary. If you just see in the top right there,
Yes.
it says his Secretary on behalf of John L. Singh, sent on the 21st of October 2010 to Mandy Talbot and others, not including you.
No, I'm included.
Are you?
Yeah, third line down.
Oh, I'm so sorry. Yes, I completely missed you. Looking at the content, Mr. Singh says, after a lengthy trial at Guildford, the above named was found guilty of theft. The case turned from a relatively straightforward general deficiency case into an unprecedented attack on the Horizon system. We were beset with an unparalleled degree of disclosure requests by the defence through the hard work of everyone, Counsel Warwick Tatford, Investigation Officer John Lonkman, and through the considerable expertise of Gareth Jenkins of Fujitsu. We were able to destroy to the criminal standard of proof beyond reasonable doubt every single suggestion made by the defence. It's to be hoped that the case will set a marker to dissuade other defendants from jumping on the Horizon-bashing bandwagon, John L. Singh. And the subject of the email is called Attack on Horizon. Can you see that?
Yes.
When he gave evidence, Mr. Singh said that you or Mandy Talbot selected this distribution list for him and told him who to send it to. Is that correct?
I certainly didn't.
Would it be usual for Mandy Talbot in civil litigation to tell John L. Singh, the case holder in criminal litigation, who to send an email to?
No. His email is on the same day as I understand the trial concluded.
Yes.
And at
It's the afternoon of the trial.
14:58. I know from looking at my diaries on that particular date, I wasn't in the office. Certainly in the morning, I was in an East London mail centre, and I don't know how long I stayed in the East Long Mail Centre, but what I do recall is when I saw this email, I was quite surprised, not only about the people that it had gone to, some of whom I have no idea who they are, but also about the content, because this is not a report that I would have prepared or any other lawyer would have prepared. And you can see that on the Henderson case, where I do the report on the Henderson.
And it's just the facts.
Yeah, absolutely.
The second thing that Mr. Singh told us was that the title of the email, Seema Misra, Guildford Crown Court Trial, an attack on Horizon, was dictated to him, perhaps by you. Is that correct?
No.
The third thing he told us was that he typed these words, or more accurately, asked his secretary to type these words, including attack on Horizon, even though he personally did not believe that the Seema Misra case involved an attack on Horizon. Did he ever express such sentiments to you? I've been forced to write an email, the title to which and the contents with which I disagree.
No.
He said, fourthly, that a collection of people dictated the contents to him, perhaps involving counsel, perhaps involving you, perhaps involving other lawyers. But then you saw a draft of the email and you approved the final draft, which is then secretary sent out. Is that true?
No.
Did you draft any part of this email?
I did not.
Did you authorize the sending of this email in any way?
No.
Did you share the view expressed by Mr. Singh that the Horizon integrity issue was a passing bandwagon upon which people could jump?
No.
Can we turn to poll 0016-9170? So we can see what happened to John L. Singh's email. If we scroll down, please. We can see just the email there at the foot of the page. And then somehow, in this version of it, we can't see how it got there, but somehow it's got from the distribution list at the bottom of the page onto David Y. Smith, Rod Ismay, who was on the distribution list, Mike Moores, Mike Young, and Paula Venables. Yes?
Yes.
David Smith, he was the managing director of the company at the time. Is that right?
I don't
David
know.
Y. Smith.
I don't know. I don't know.
Paula Venables was head of network, post office network.
I recognise Paula Venables' name because I think she became the chief executive of...
Subsequently, at this time, I think she was head of network.
Right.
And then if we go on further up the page, please. We can then see Mr. Ismay redistributes the email back to everyone who was on the first list. Can you see that?
Yes.
Including you.
Yes.
Dear all, please note Dave Smith's thanks to you all for your work on this important case. Dave and the executive team have been aware of the significance of these challenges and have been supportive of the excellent work going on in so many teams to justify the confidence we have in Horizon and in supporting our processes. This is an excellent result and a big thanks to everyone. So Rod Ismay here is making sure that everyone saw how pleased David Smith was with the outcome. Yes?
Yes.
This circulation list includes some of the same people that we saw in the congratulatory email after the Castleton trial, including you, Mandy Talbot, and Rod Ismay, as well as successor people like Susan Crichton, the General Counsel. Do you see any pattern emerging between the emails?
Yes.
Both followed trials which had challenged the integrity of Horizon. Yes?
Yes. Yes.
Both were gleeful that the challenge was defeated.
Yes.
Both victories were seen as a way of sending a message out to the sub-postmaster community.
Yes.
And both were evidently of interest and importance to senior people within the post office, weren't they?
Yes.
You say in your statement that you cannot recall what you thought at the time about the outcome of the case, but you were surprised at the audience.
Yes.
Why were you surprised at the audience?
I didn't realise that it was being watched effectively by pretty senior people within Post Office Limited.
How's that come about? As head of criminal law, surely you should have been aware that the managing director, David Y. Smith, and the executive team were aware of the significance of the challenges that the Misra case presented.
Well, I wasn't aware. They weren't contacting me. I wasn't contacting them. Mr. Singh wasn't telling me that lots of people were interested in it.
As far as you were aware, was it just another run-of-the-mill case then?
Well, it certainly was when I allocated it to Janelle, but in terms of disclosure, it took on a life of its own. But, I mean, I didn't view it at any particular stage as a test case, which clearly other people were viewing it as. For me, it was another case with a lot of disclosure.
Given the defence that Mrs. Misra was running, in short, that Horizon had created fictitious shortfalls
Yes.
in her accounts, if she had been acquitted,
Yeah.
do you think that would have opened up the strong possibility of attacks on past convictions secured on the back of Horizon evidence?
I think, looking back now, I think that probably you're right. I think having seen the amount of disclosure and then being told by a jury we're not going to convict would have been a defining moment, yes.
It may have called a halt to Horizon prosecutions.
It may have done, yes.
Would you agree that although your department would have been in the vanguard of driving that process of looking back at past convictions and halting current prosecutions, the implications would have been felt across the entire post office estate, not i.e. they would have had effects not just on prosecutions?
Inevitably, yes.
Can you therefore now understand the relief that's expressed in these emails that she was convicted?
I saw from the senior people,
Yes.
not from Janelle Singh.
Well, from both, actually.
Well, I saw Janelle Singh as being relieved on the basis that it was probably a stressful period for him, and that lent it took towards the language that he's actually used. So when I saw the first email, whilst I was surprised, I put it down to stress, because I think had I not understood or believed that that was the position, I think I would have had a word with him about his use of the language, because it was inappropriate. With the senior people here, yes, I mean, I probably wouldn't have seen a congratulatory email like this at all if the case had been, if Miss Seema Misra had been acquitted.
You were on the distribution list, as you rightly pointed out, of the original email.
Yes.
And of this reply after it's done the rounds
Yes.
amongst senior people within the post office. You didn't pull Mr. Singh up on it, did you?
No, as I said just now, I thought his reply was probably generated by a relief, relieving his stress.
Or is the truth that you were also personally invested in the outcome of Seema Misra's case? After the Lee Castleton congratulatory email sent to you, after your email about not setting up an independent expert evaluation of the integrity of Horizon, after your sight of the ISMAY report, you can't have been in any doubt that the business was interested in cases which challenge the integrity of Horizon, can you?
Well, I wouldn't have been in any doubt seeing this, that the business was interested in the result of cases.
Well, therefore, you can't have been surprised at the audience of this bandwagon email.
Well, it was a surprise.
But why? If
Because
after all of the events which had happened, the last round, the big challenge was Lee Castleton, after the proposal to get an expert evaluation of the integrity of Horizon, which you on balance argued against, after the disclosure issues that we've looked at, after the ISMAY report, you knew what was riding on this case, didn't you? And therefore, how everyone would be interested in its outcome.
I really don't see that as being in my brain. No, I think I was quite surprised. I mean, the Lee Castleton thing, I had virtually nothing to deal with, because all I did was say, yes, I'll come to court and explain why Mr. Singh was acquitted. The Rod ISMAY report, I had very little to do with that. I think I may have given some information about cases that we've been prosecuted, but I had very little to do with that. and was quite surprised because I'd forgotten about the pending report when it came through. These things were happening over an extended period of time, and they weren't always in the front of my memory. I'm not trying to make an excuse. Maybe I should have been aware that there was a big interest in this, but all I can remember about the final email here was being surprised at the number of people that clearly had been interested in it and that I was unaware of.
That can come down, thank you. We've looked at a series of emails of what happens when the Post Office is successful in civil proceedings or criminal proceedings. Can we look at what happens when the opposite comes about? Tony Utting, gave us evidence on the 17th of November of this year, and he told us that when the Post Office lost the case, there would be a report which was written by counsel that would go to the criminal law team and the leadership team about why it had been lost. Is that correct?
Certainly, if we lost a case, I would ask counsel for a report on the case, giving a view as to why he believed or she believed that we'd lost it, yeah.
And what would you do with that report?
Well, I would be forwarded up to my line manager, whether it was Andrew Wilson or Tony Utting or whoever.
And what was the purpose of doing that?
Well, the purpose was if there was a problem identified by council, we would try and rectify it or understand what went wrong and provide training or whatever was needed.
In January 2007, Mrs. Suzanne Palmer, after a 3-day trial in which she had raised Horizon integrity issues, was acquitted of 3 charges of false accounting, with the jury acquitting her after about 10 minutes. The jury asked the question, what was Mrs. Palmer supposed to do if she did not agree with the figures that the Horizon system produced? The Post Office representatives at court were unable to answer that question. Was there a post-trial report in that case?
There will have been. I can't remember.
The jury raised in public a question as to the reliability of the Horizon system and what a sub-postmaster was supposed to do if, in that case, she did not agree with the figures. And the Post Office was unable to answer it at court. Was any review undertaken in the light of this outcome?
I don't recall the case at all. I imagine there should have been a review. I imagine there would have been a review, but it seems to me extraordinary that they don't know that she could have reported that to. I can't remember the initials of the group that dealt with problems. I'm surprised at that.
We haven't got a review or a report back to you. The only emails we've got are gloating emails when the Post Office wins. Do you know why that is? We've got no reviews of when cases are lost by the Post Office.
Well, it could be that it wasn't by email. I mean, the council may...
Okay, reports or any document or piece of paper.
I have no idea how the Post Office disclosed all these documents on you, but I did ask for, on every case that we lost, I asked for a report from our council who was dealing with it, and if it was an agent's case, I'd also ask for an agent to give me a report. So I will have got a report. I'm pretty confident about that. I don't recall it though.
Thank you very much, Mr. Wilson. So I wonder whether we might take the afternoon break now until 3:20.
Yes, very well.
Thank you, sir. Afternoon, sir. Can you see and hear us?
Yes, thanks. Yeah.
Thank you. Good afternoon, Mr. Wilson. Can we turn, in fact, before we turn to that, Ms. Gallifant has kindly pointed out to me that poll 3049716 needn't be displayed, shows that David Pardo was the person who authorised the prosecution of Seema Misra. Thank you. Can we turn, please, to Alison Henderson? You were the relevant lawyer in Mrs. Henderson's case, yes?
Yes.
Can we look, please, at poll 3044501? Can we scroll to the foot of the page, please? Is this right, a memorandum from the investigator to you,
Yes.
dated the 20th of April 2010?
Yes.
And then if we scroll up, please. Is this essentially a memorandum seeking your advice on charges? Just take a moment to read it to yourself.
It's not the traditional report that I'd expect to see.
Have I picked the story up sort of halfway through? If you look just towards the bottom of the page that's being displayed there, where it says, I hope you feel we can continue with charges of theft or false.
I think so, yeah. The normal report is slightly different to that.
Yes. You tell us in your witness statement, I wonder whether we can turn it up then, please. It's page 21 of your witness statement. At paragraph 33, you refer to some documents earlier in your statement, and you say, I believe after having reviewed the documents that the first time I became aware that the integrity of Horizon data was being questioned was upon receipt of the amended defence statement dated the 16th of November 2010. I received an indication that Mrs. Henderson was highly likely to plead to false accounting. The receipt of the challenge complaining of the malfunction of Horizon would have raised an obligation on the defence, an obligation to serve on the defence any material that assisted the defence or undermined the prosecution. And then you say this, I do not believe that ARQ data was ever sought in this case. And that certainly matches the material that we have got. If, as you said at the outset of today, that ARQ data was fundamental in at least those cases where Horizon data was being questioned or the integrity of Horizon was being questioned, why wasn't ARQ data sought in this case?
Well, I think it will have been sought had she maintained her not guilty plea, but I think the defence statement of the 16th of November crossed with a telephone call of either the same date or the date before with the defence solicitors who telephoned me to say that it was in counsel's hands, but it was likely to be a guilty plea. And then 5 or 7 days later, counsel to counsel had had a telephone call where the defence said that she would be pleading to she would plead to false accounting and would not be challenging Horizon. Had she maintained a not guilty plea, we would have been looking at ARQ data, ARQ data.
Can we look, please, at that train of events, poll 305-5807? a letter of the 18th of November from Defence Solicitors Belmores to you. A question: we act on behalf of the above name and wonder whether you might accept a plea to false accounting in this matter, as well as full repayment of £12,000 odd outstanding. To what extent was repayment of alleged losses ever made a condition of acceptance by the Post Office of a plea?
To say I wasn't interested in repayment is underplaying the statement, but that was not a primary concern of mine, and I don't believe I made it a condition with Belmores. I think they were offering this.
Can we just look at what the defence statement said? Poll 304 4503. Defendant doesn't dispute that £12,000 odd appears to be missing. She offers no particular explanation and doesn't understand why there's a discrepancy. However, does believe that any discrepancies are the result of a malfunction of the Horizon computerised accounting system. She believes that any discrepancy could have been discovered by the Post Office auditor, particularly as he initially alleged £18,000 was missing. This was reduced to the alleged sum in a matter of minutes. Further investigation by the auditor would have discovered the whereabouts of the alleged missing sum. Categorically denies appropriating any money for the Post Office, not in any financial difficulty, of good character, has not moved any monies or made significant purchases. She accepts that she's contractually obliged to pay the amount of £12,000 odd to the Post Office and has instructed her solicitors to approach prosecution as to how best this can be achieved. Can we see what your response was to the defence statement? Poll 305 5783. Top of the page, 17th of November, have received a defence statement today. Despite the telephone conversation today, hard copy's been put in the post today. The defence alleged any discrepancy was a result of the Horizon system. And then last paragraph, clearly, if there were to be a plea to false accounting, but on the basis that the Horizon system was at fault, that would not be an acceptable basis of plea for the prosecution. Can we look, please, at poll 304 6865? And look at page 7, please. Thank you. This is Alison Henderson's questionnaire as part of the complaint review and mediation scheme. And can you see at paragraph 6, the second bit of it, she, that's Mrs. Henderson, was advised to plead guilty to false accounting in return for dropping the theft charge. She was also told she could not mention any problems with Horizon in court. Can you see that?
Yes.
I think you know that that can come down, thank you. I think you know that the Court of Appeal in its Hamilton judgment, insofar as it concerns Alison Henderson, noted that the Post Office conceded that it was improper to make the acceptability of Mrs. Henderson's plea to false accounting conditional upon making no issue of the Horizon system. The Court of Appeal continued, in our judgment, such conduct on the part of a prosecutor is improper. The Post Office had dropped the theft charge and so could no longer advance any case that she had stolen the money. The Post Office concedes that she, Mrs. Henderson, that should have left the way open to Mrs. Henderson to suggest that there was no actual loss and she had only covered up a shortfall that Horizon had created. Do you accept, as you did before, what the Court of Appeal says?
I wouldn't seek to argue with the Court of Appeal at all in any shape or form. But the reason I was putting that in there was in the event that she did plead guilty to the false accounting, then I refer back to what I put in my witness statement a number of times concerning the agreement, if there wasn't an agreement between the prosecution and the defence in terms of the difficult. I'm phrasing this really badly. The difficulty in the case, then it was you'd effectively have a Newton hearing. I mean, that was what I was trying to do, but I accept that I've put it in a very different and difficult way in that document that you've just shown me. Yes.
With hindsight, do you accept that it wasn't proper to make the acceptability of the plea, or the basis of plea to false accounting, conditional on making no issue of the Horizon system?
Yes, I think what I've done is wrongly worded it. What I should have said was that in the event that we have a disagreement about culpability, then it'll probably have to be dealt with as a Newton hearing, or words to that effect. Yeah, I've put it in the wrong way. I accept that.
In Mrs. Henderson's case, did you disclose the receipts and payments mismatch bug documentation?
No.
Did you disclose the Rod Ismay report?
No.
And why was that?
The Rod Ismay report, as far as I was concerned, was a vindication of the Horizon system, and I didn't see that as undermining our case.
Did you expressly consider it?
Did I expressly consider
It for disclosure?
No, basically because I felt that it didn't undermine our cases.
When Mrs. Henderson lodged her defence statement, did that not trigger an obligation to review what material existed within the post office generally, without going to Fujitsu in the first instance?
Yes, it would have triggered disclosure, yes.
Is it right that there wasn't a central repository, whether physical or on a server, for investigators and prosecutors to access of all information relating to alleged or established problems with Horizon?
Yes, it's right. I know it was suggested by counsel in an earlier case who represented the sub-postmasters and mistresses, a large number of them, and I think it was an opportunity we missed.
Was active consideration ever given to that, to have a central repository at which established problems with Horizon, some of which we've seen today, or alleged problems with Horizon, could be accessed?
Not that I recall, but as I say, I think it was an opportunity missed that we should have done something like that, yes.
Who within the post office was responsible for thinking of such an idea and carrying such an idea into action?
Well, I could have done, and I should have done, but I don't think it ever occurred to me, and I don't think anybody ever suggested it as a good idea.
Can we turn lastly to Khayyam Ishaq's case? and turn up paragraph 50 to 53 of the case, of your witness statement, which is on page 27. You say, I did not have a role in relation to disclosure. You weren't aware that Mr. Ishak had raised horizon integrity issues in the course of the prosecution, and you had no involvement in the prosecution after you moved to the Royal Mail Group in 2012. Is that right?
Yes.
Who took over responsibility from you when you moved in 2012?
Mr. Singh would have been the lawyer in Post Office Limited.
But you had overall responsibility for the case until April 2020, is that right?
Yes.
You, a year earlier, had authorised prosecution, is that right? Advising that there was sufficient evidence of a realistic prospect of conviction.
Yes.
I'll give the
Oh,
reference.
no. Did I?
Well, let's have a look at it. Poll 305 6596.
I thought Cartwright King gave the.
Can you see this is a memorandum dated the 5th of July 2011
Yes.
in the case of Kayam Ishak? If we go to the last page, we scroll down, we can see it's written by you.
Oh, right. Yes. I was under the impression that I hadn't started the case.
If we go back to the first page, please. In my opinion, paragraph 1, the evidence is sufficient to afford a realistic prospect of conviction on the charges set out on the attached schedule.
In that case, there is a mistake then in my witness statement, because I put at answer number 47, the charges drafted by Martin Smith of Messrs. Cartwright King.
Whereas in fact it's you.
Well, that's showing me as me, isn't it?
Did you ever analyse or reduce to writing such analysis of why there was a realistic prospect of conviction?
No, I don't think so.
Your advices tend to follow this format, namely a statement as to there is a realistic prospect of conviction, and then the rest of the memo turns to evidential queries that need bottoming out.
Yes.
You don't say why there is a realistic prospect of conviction.
No, I don't.
Was there a separate record kept of why there was a realistic prospect of conviction?
I don't think so, no.
After April 2012, did you have any involvement in the proceedings against Mr. Ishak?
No.
Thank you very much, Mr. Wilson. They're the only questions I asked. That document can be taken down, please. I think there are some questions, including from Mr. Jacobs to start with.
I just have a quick question to ask you. I act for 156 sub-postmasters who were affected by this scandal. And I want you to cast your mind back, but not very long, just to 9:15 this morning.
Right.
And Mr. Beer asked you a question, and he said, if you were asked from 2000 onwards, and if there's any change in the answer from 2000 until, say, 2012, who at board level was responsible for the conduct of criminal prosecutions,
Yes.
what would your answer have been? Do you recall that question?
Yes, I do. Yes, I do.
And so I'll remind you of your answer, just so we've got it on the transcript.
I think I said the secretary, didn't I?
You said the answer would be the company secretary. And then you went on to say, yes, I think there were probably 2, possibly even 3 while I was there. And for the life of me at the moment, I can't remember their names.
Yes.
Now, Howe & Co have been quite diligent, and we found
Right.
from documents the names of the company secretaries in Post Office Limited who were in place from the years when you were in place, 2000 to 2012. And our clients are very interested to know the names of the individuals who would have known or ought properly to have known what was going on with the Horizon system and
The reason I said that I think it was the secretary was because I know that my direct line, the security director, reported to the secretary.
Right.
So that was my rationale.
Yes. So your evidence is still then
Yeah.
that your understanding is that the person at board level
Yes.
who was responsible for the conduct of criminal prosecutions was the secretary.
Yes.
And just it might help remind you of the names if I give you those names,
Yes.
and you can confirm whether that's right. So from 1999 to 2010,
Yes.
the company secretary was Jonathan Evans. Does that
Right.
ring a bell? Is
Yes.
that right?
Yes.
He was one of the 3.
Yes.
And then from 2010 to 2011, for a period of about 18 months, it was Susan Crichton who also held the role of general counsel. Do you recall that?
She was general counsel.
But she was also, it seems, the company secretary as well.
Right. Okay. I didn't understand that. I didn't know that.
Okay. And so she wasn't one of the 3 that you, 2 or 3 that you...
No, she wasn't one of the 3 I was thinking about.
And the third one, from July 2011 to 2017, and we know that you went to Royal Mail in 2012, is Alwyn Lyons. Is he one of them?
I've never heard the name.
So you can definitely confirm from what we've now been through, Jonathan Evans.
Yes.
Okay. Well, I'm just going to ask to see if I have any more questions. I don't. Thank you very much.
I think Mr. Henry has some questions.
Thank you, sir. Mr. Wilson, I represent, among other people, Seema Misra. I suggest your evidence today has revealed that the criminal law team was the submissive servant of the Post Office's commercial interests or perceived reputational advantage. Do you agree with that?
No, I don't.
That your department's duties as a private prosecutor were twisted, degraded, or suborned in the service of the Post Office's interests as a business. Do you disagree?
Yes, I do.
That prosecutorial standards and duties were subordinated routinely to ruthless commercial imperatives. That's right, isn't it?
No.
And that far from displaying candour and disclosing information concerning system errors to sub-postmasters and criminal and civil courts, your department sought to suppress such information.
No.
You have said, in respect of the documents that you received on the 8th of October 2010, and we'll come to one of them very briefly in a moment, that without wishing to be facetious, you said that you must have had a bad day at the office when you decided that the contents of those documents concerning the receipts and payments mismatch bug were not disclosable. Do you remember saying that?
Yes.
I suggest that it was not an isolated error and that this was part of, whether it was reckless or Nelsonian, a policy of taking perverse decisions on disclosure to protect the Horizon system. What do you say about that?
No, I didn't take decisions to protect Horizon.
Could we go, please, to FUJ? There is an equivalent POL document, but if we could go to FUJ 000 81584, please. Now, the people in this document, some of them were known to you, were they not, apart from Mr. Simpson?
The only name I recognise there, apart from Alan Simpson, is Gareth Jenkins.
Not Mr. Wynne of POL Finance?
No,
Not Julia Marwood, who was an investigator and part of Network?
no,
Not Emma Langdale, who was part of the Post Office's problem management team?
no,
None of those.
no.
You read that document, presumably, on the afternoon of the 8th of October.
Was I copied into an email with it?
It was sent to you by Mr. Simpson.
Oh, right. This is the... right, okay, yes.
Yes. Could we go, please, to the impact section, please? This is all predicated on the effect of the receipts and payments mismatch bug. Very, very quickly, because the Learning Council to the inquiry has already gone through it. The branch will have appeared to have balanced, whereas in fact they could have a loss or gain. Our accounting systems will be out of sync with what is recorded at the branch. And then emphasis, please, with the following words: if widely known, could cause a loss of confidence in the Horizon system by branches, potential impact upon ongoing legal cases where branches are disputing the integrity of the Horizon data. I emphasize ongoing legal cases. And then finally, it could provide branches ammunition to blame Horizon for future discrepancies. Now, none of those concerns, you agree, Mr. Wilson,
Yes.
would count for anything in the discharge of your duties under the Criminal Procedure and Investigations Act if that material was disclosable.
Sorry, say that again, please.
None of those concerns
Yeah.
would count for anything if the material was disclosable. In other words,
Yes, no, I understand what you're saying. Yes, I agree
yes,
with you.
right. Is there any record of you remonstrating with Mr. Simpson about that, or drawing that to his attention?
I don't know.
Do you accept that this document, in which a number of people from the Post Office, together with a number of people from Fujitsu were present, reveals a fear that if flaws in Horizon became widely known, that sub-postmasters might exploit this?
Yeah, that's what it's saying.
Yes?
I'm not saying I agree with it, though.
But you see and you accept that that is what it says?
Yes, I can't dispute what it
Right.
says.
And that therefore the mindset might be that it would provide branches ammunition to blame Horizon for future discrepancies. In other words, people could take dishonest advantage of it. That must be the import of what that is saying.
Yes.
Right. What I suggest is that you became aware of that document, you forward it to Mr. Singh, you forward it to Ms. McFarlane, but the vulnerabilities were suppressed, weren't they?
No, I wasn't suppressing the vulnerabilities. I didn't agree with the solutions. My view was that all of the sub-postmasters and mistresses should have been told about the bug.
Well, you accept, do you not, that by this time, October 2010, concerns about the Horizon system, and this was the finding of Mr. Justice Fraser, concerns about the Horizon system had been in existence for 10 years by this time?
Yes, if that's when they first became known, yes.
And you have, in your evidence today, conceded that you were aware from 2005, 2006, about suggestions about system vulnerability, haven't you?
I'm not sure of the dates, but I've agreed with what council put to me, yes.
Well, could we please, you've just said that you didn't agree with the solutions, so it follows that you must have read the solutions in detail if you were going to disagree with them.
Yes.
Could we go to solution number 1, please? I want to concentrate, please, on solution number 1. Alter the horizon branch figure at the counter to show the discrepancy. Fujitsu would have to manually write an entry value to the local branch account. Impact. When the branch comes to complete next trading period, they would have a discrepancy, which they would have to bring to account. And then this, risk. This has significant data integrity concerns and could lead to questions of tampering with the branch system and could generate questions around how the discrepancy was caused. That must be the discrepancy referred to in impact. Do you agree?
In the impact above,
Yes, in the line immediately above.
when the branch comes to the next, yes.
Yeah. So a discrepancy would have appeared out of thin air, which they would then have to bring to account. Then the final sentence, this solution could have moral implications of post office changing branch data without informing the branch. Now, your evidence earlier today was that you believe that that referred to an individual visit to each branch to go to, not figuratively speaking or metaphorically speaking, the counter, but to the actual counter to alter the data. That was your evidence.
Yes.
I suggest that that evidence is untenable in view of the last sentence. This solution could have moral implications of the post office changing branch data without informing the branch.
Well, it could have moral implications if they're not telling the branch that they're altering the data at the counter. That's dishonest.
Of course, it would be, but we're not talking here about them coming along and saying, I need to do something with your terminal at the branch, the terminal which is on the counter. What we're talking about here is the covert insertion of data authorized by the post office and implemented by Fujitsu. That's what we're talking about, aren't we?
Well, I didn't read it like that, and I never believed that there was a back door into the office, the sub-post offices.
Mr. Wilson, did you make any attempt to clarify the disturbing contents of those passages that I have put to you?
I think what I did was I spoke to John Longman, was it Alan Simpson, and said that the only acceptable solution in relation to these, in relation to this issue, was to inform every branch, every sub-postmaster what the problem was, and to have it fixed in line with, I think, the suggestion that was in the second attachment by Mr. Jenkins.
Mr. Wilson, that wasn't the question I asked you. I asked you, did you do anything to clarify what appears to be an obvious interpretation of remote access? Did you do anything at all to clarify with anybody the disturbing contents of what I have put to you?
Well, I didn't understand it to be remote access.
I suggest that it cannot be interpreted in any other way, Mr. Wilson. It must be remote access.
Well, I didn't understand it to be.
And that, of course, would have been disclosable whether it was Legacy Horizon or whether it was Horizon Online, wouldn't it?
Well, that would have stopped prosecutions completely.
Of course it would. But moving on, and this is the final matter, do you not agree? I mean, you say that it is now, in retrospect, clearly disclosable, but do you not agree that a continuum of error, whether it be in Legacy Horizon or Horizon Online, in other words, complaints about the fragility of the system and instances of system error, would be disclosable in a Legacy Horizon case, even if it were to refer to Horizon Online?
I do now,
Well, why didn't you then?
because I believed that there were two separate systems, and the new Horizon, as I phrase it, was not impacting on the old Horizon.
But if you look at it in this way, and surely this would have been apparent to you, the old system was perceived to be subject to bugs, errors, and defects, and so therefore a new system which was attempting to be more robust than the previous system was being rolled out. Correct? You follow me?
Yes.
And yet the new system, contrary to expectations, results in these covert balancing errors, which sub-postmasters are completely blameless and totally unaware. That must be disclosable, mustn't it? Because it goes to the ability of Fujitsu to actually implement a correct system.
Well, I agree with you now, yes.
Does this not, and again, I ask this, and I ask you, please, to reflect carefully before you answer. Does this not reveal a symbiotic relationship between Fujitsu and the Post Office? The Post Office protecting Horizon at all costs for both its own reputation and Fujitsu aiding and abetting it to serve its own commercial interests as well?
I think at a high level, having considered all of the documents that I've seen and listened to arguments like you're putting now from counsel, that at a high level, yes, there was a protection of Horizon.
And of course, you were involved in that high level in relation, of course, albeit at a distance, but nevertheless in relation to the laudatory plaudits you received from David Y. Smith, Rod Ismay, and Paula Venables, weren't you?
No, I wasn't inviting plaudits. I was surprised. I didn't know most of the people on the list. I'd never met either of the three that you've just named. I didn't realise that the interest was as such as it's been demonstrated in the document. I'm very sorry, but I didn't.
Thank you very much.
Anyone else?
No, that's it, sir.
Well, thank you for returning to give evidence, Mr. Wilson. It's been a full day for you, but I'm grateful for your participation in the inquiry.
Thank you, sir.
10 o'clock tomorrow, Mr. Beer?
Yes, that's right, sir. Thank you.